We are now going to jump in, dive in deeper. We've had our overview in chapter 11. Now we're going to start looking at the individual elements. So agreement is one of the four, or five if you count form, one of the four elements of a contract. You must have agreement. And if you're going to prove that a contract exists, you have to prove that an agreement exists. In order to prove that an agreement exists, you typically want to prove that an offer existed and so did acceptance. If you prove that you had an offer made and that it was accepted, you can prove that there was an agreement, and that's one of the four elements you must prove. So what you're looking for is mutual assent. So we have some rules that help us there. For an offer to be a legal offer, we want to show the court or the jury that the offer was made with the serious intention to be bound, serious intent to be bound, that the terms are reasonably certain or definite. We know what the terms were and that the offer was communicated. So we have serious intent, we have terms that were certain or definite, the definiteness of the terms, and that that offer was communicated. Right? That's the requirements of proving up an offer. Intention is going to be a reasonable person in the offeree's position. Right? We have this Lucy versus Simmer. You should read the case. That is a high as a Georgia pine case. You should definitely read that case for the proposition that it doesn't matter if you were slinging whiskey back all night, you wrote it on a napkin, we're going to enforce it. Because a reasonable person would have understood it that way. You should read the case. It's 12-1, Lucy versus Zimmer. Here's an instance where intent may be lacking. Expressions of opinion. I think this car is worth $50. Sold. I think this car is worth $50,000. Sold. That's just an expression of an opinion. It's not enough. Statements of future intent are most of the time not enough to be an offer. Preliminary negotiations or invitations to negotiate in the future, not an offer. Advertisements, not an offer. Now, there are some cases where an advertisement can be an offer, but they're rare, and I haven't seen one in print. I have nothing to show you from my history where I've ever seen something in print that was a real offer. It would have to be something like this. The first two people to show up on the showroom floor with money ready to go will get this car for $10,000 off the sticker price or something like that. It would have to be probably a unilateral offer and would have to be limited. Advertisements are typically invitations to negotiate. Online auctions, eBay, typically not offers, but invitation to submit offers. So the auctioneer is asking you to submit your offers, and then the sold is the acceptance. So it's kind of backwards. In some agreements to agree later, we might lack intent. In preliminary agreements, lack intent to be offers. Definiteness of the terms. So the definiteness of the terms, although intention is really, it's straightforward to prove up one way or the other, the definiteness of the terms sort of have some sub-elements to them. So if you want to ensure that you have the terms that are definite, so let's assume there's no question that the offer was serious, and there's no question that it was communicated. There may be a question of whether or not the terms were definite enough or not. We at least want to know the identification of the parties. We want to identify the subject matter. We want to identify the consideration to be paid, and we want to identify the time of payment, delivery, or performance. So we want to know who the parties are, what this is about, what the consideration is to be paid, and when. And if you can show those four things, you probably have definite enough terms. Probably have definite enough terms. And in some instances, for the consideration to be paid and the timing, a court will supply missing terms because it will basically assume the parties intended a reasonable amount of time and maybe market rate. And then you must communicate the offer. You can't agree to a bargain without knowing that it exists. You just can't. You must communicate it. So you prove up a serious intent to be bound, you prove up the definiteness of the terms, and you prove that it was communicated. You have proved up that an offer existed. But there are some ways to terminate an offer. An offer can be terminated either by action or by operation of law. So I want you to picture this with me. When you make an offer, I want to picture you putting a caterpillar on the ground and letting the caterpillar go, walk over, crawl over to the offeree. You, as the offer-making person, are called the offeror, and you create caterpillars. If you make an offer, you are creating a caterpillar and letting it crawl over to the offeree, who then has options. If the offeree rejects your offer, it is like stomping on the poor caterpillar. And once you've rejected an offer, you can't accept it. Once you've rejected an offer, you can't accept it. The caterpillar is smashed. You can also accept the offer, though. And the way I want you to think about it is if you accept the offer, the caterpillar turns into a butterfly. Right? So a contract is equal to a butterfly. An offer is equal to a caterpillar. So you can terminate an offer by rejection or by revocation. So who revokes an offer? If I make the offer, I can revoke the offer. If I did not make the offer, I do not have the authority to revoke it, but I can reject it. So a revocation of the offer would look like this. I just made this caterpillar and sent it over to you. Before the caterpillar reached you, I revoked it by stomping on it myself. Right? And a counteroffer is really nothing new. It is a rejection plus another offer. And what happens with a rejection? You kill the caterpillar. So if I say to Sue Smith, I'd like to take you out on Friday for dinner. And Sue Smith says, no, thank you, that is rejection. If I say, Sue Smith, I'd like to take you out for dinner on Friday, and Sue Smith says, I can't do Friday, but how about Saturday? And I say, absolutely, Saturday's great. What has happened in that case is I offered her a Friday night meal and she rejected it. She stomped on the caterpillar. Yet she immediately offered me, right? She offered me a caterpillar. So she stomped on my caterpillar and immediately said, well, not Friday, but how about Saturday? And then I said, yes, 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 yes. That means I turned her caterpillar into a butterfly. This is important, and I really promise you this will help you if you're an accounting student, and it's a long time between the time you take this class and you take the CPA exam. The caterpillars and butterflies will help you because it will keep it straight in your mind which offer was actually accepted, who the offeror was, and who the offeree was. So just know you can revoke if you're the offeror, you can reject if you're the offeree. You can also make an offer irrevocable, and that is sometimes helpful in business. If you buy a house, you'll probably use one of these, and that is having a separate contract called an option contract. And that basically means that you're making the offer irrevocable. You got to pay for that with an option contract. So if you basically have a side contract that says, I promise not to revoke this offer for 1 month, and if I do, I'm in breach of this contract. And so that's an option contract. Rejection can happen by words or conduct. And if that happens, you've terminated the offer. You've terminated the caterpillar. Counteroffer is a rejection. Don't forget that. It's a rejection plus a new offer. When we have the mirror image rule in contracts, now if it is a UCC-based contract, it's not exactly a mirror image rule. But the mirror image rule, at least at common law, any change in terms automatically terminates the offer and substitutes a counteroffer. So the mirror image rule says if you make any changes to the contract, you've rejected it, and all you have done is made an offer. So if you get a contract and you make a change and then sign it, it's nothing until the original offeror, who has now become the offeree, signs it. You can also have a termination by operation of law. This offer will remain open for 30 days, and on the 30th day at 5 p.m. Central Standard Time, this automatically is revoked. It's an offer that will, by operation of law, terminate the caterpillar. If you destroy the subject matter, now this is only for an offer. This is not for a contract. The destruction of the subject matter can void the contract, rather the offer. I just misspoke. Destruction of the subject matter. If I promise to sell you my pen for $5 and before you accept it tomorrow it gets destroyed, the offer is automatically, by operation of law, the offer matter is terminated. Death or incompetence of the offer or offeree. If I offer to sell you my pen for $5 and I die before you accept it, you can't accept it because the offer was terminated. If I offer you $5 to buy my pen before you accept it, you die, the offer is terminated. This is not the same thing as if you have a contract in existence and you haven't fully performed. In that case, the person's estate may be liable. This is just for offers. If you have, we'll talk about marijuana. Let's assume that you have a legal contract for the sale of marijuana, and this is a long, long time ago, before America or the United States made it illegal. And so you have a contract to sell 2 ounces of marijuana to a doctor, and no one has accepted the offer yet. The doctor hasn't accepted it, and all of a sudden there's a new law that says marijuana is illegal. The offer is terminated by operational law. Now, this actually happened with clove cigarettes while I have been teaching, in fact. It was perfectly legal on one day to buy and sell clove cigarettes. The very next day, because of the legislature, it's actually the FDA, the very next day it was illegal. So if you made an offer to sell clove cigarettes, the day when it was legal and no one accepted it until the day after it was legal, there's nothing to accept because supervening illegality makes it terminate, and that is by operation of law. Now, what acceptance is a voluntary act or statement that indicates assent to the terms or agreement. Offer plus acceptance. It has to be unequivocal, because if you change the original offer, it's a counteroffer. Silence or inaction generally cannot be acceptance. There are some exceptions to the rule, prior dealings, but those are exceptions. Silence is typically not acceptance. If you have prior dealings, it may be proven up by the context. If someone has a duty to reject and doesn't, you may be bound. But the general rule, silence is not acceptance. If you, however, act consistent with acceptance, it could be considered acceptance. So if you were to go to the store and you were to put a candy bar on the belt at the cash register, and the cashier were to ring you up and you were to give a $5 bill and the cashier gave you change, after you've done that, you can't come back the next day and say, we didn't have a contract because I didn't accept it. Right? That is behavior that is consistent with acceptance, and it would be deemed accepted. How do you accept? With a bilateral contract, communication of acceptance is necessary because of the mutual exchange of promises. You have to talk or write. A unilateral contract, acceptance is only evident when you start performance. And that's the only way you can accept. If I say I'll give you 100, or I think it was 500, I don't want to change the deal. I promise to pay you $500 if you mow my lawn on Friday. If at 4:30 you start mowing my lawn, it will be clear to me that you're attempting to accept. Once you finish mowing my lawn by 5 o'clock, you have accepted my offer, and I owe you $500. Acceptance is timely if acceptance is communicated before the offer is terminated. Before the offer is terminated. This is a difficult rule, but I want you to focus on the word deemed. Acceptance is deemed communicated and is thereby effective when the offeree drops a written acceptance in the U.S. mail. It is considered or deemed accepted upon dispatch. This only affects acceptances, not rejections. It does not pertain to offers. It is only an acceptance. It's deemed effective or deemed accepted, so therefore is effective upon dispatch. Otherwise, any authorized means is appropriate. You do not have acceptance if you use an unauthorized means to communicate, although that can be ratified. If you use a substituted means, the acceptance can be effective, but essentially that's the ratification kicking in. If the substituted method serves the same kind of purpose as the authorized means. Typically, I would follow the directions of the offer because then you don't have any questions. That's agreement. Agreement. Offer plus acceptance. How do you prove up an offer? You have to show serious intent to be bound. You have to show that the terms were definite enough, and you have to show that the offer was communicated. Well, how do you prove that the terms are definite enough? Well, identify the parties, identify the subject matter, identify the consideration, and the timing. Agreement in e-contracts is interesting. We are only going to look at a couple of these slides and then move through them. This happens all the time these days. You click something. You can donate to charities. You can do all sorts of things. And an e-contract follows the same rules as regular contracts. You must meet the same requirements. But the way we do it is changing, and it's changing now. When I graduated from law school, I didn't have an iPhone. When I was in law school, iPhones didn't exist. Everyone, upon graduating, got a BlackBerry at their big firms, not an iPhone. So think about how the world has changed now. We have iPhones over the past few years, and there will continue to be more iPhones, bigger and better iPhones, right? So this kind of context for contracts is changing. At the end of the day, it is the same principle. Is the same principles that apply. How many of you have clicked through and said, I accept without actually reading it? Have you ever done that? Well, if we had a subjective theory of contracts, that would be no good. Some contract creators are forcing you to scroll down to the end to at least make it seem like you had an attempt to read it rather than just hit accept. But every online payment, everything you do online has a contractual component. And some offers online, they have limitations on remedies, and they have forced arbitration clauses and form selection clauses, meaning that they can force you to come to Nebraska if you live in Texas and you probably consented to it. A form selection clause forces a location of someone's choice or jurisdiction where disputes will be resolved. So we could agree in Texas to have a form selection clause in our contract that says we have to go to Monterrey, Mexico. That's the jurisdiction where the dispute will be heard. Choice of law, we could say, well, you have to go to Monterrey, Mexico, but you have to use Colorado law. We can do those things, a form selection clause or choice of law clause. The way that you get around the illegalities of usury in Texas by out-of-state banks is by choosing law in another state that allows for a much higher interest rate than Texas does. Choice of law happens all the time, and they can be quite helpful. Here's these click-on agreements. A binding contract can be formed by clicking on a box. The law does not require that parties read all the terms. It is an objective theory of law or contracts. If you ever bought a piece of software, you may have had a shrink wrap agreement. And those are agreements whose terms are expressed inside the box containing the good, not outside. If you open the box, you agree to the terms by keeping merchandise. A browse wrap agreement, like a click-on agreement, can occur in transactions over the internet. Unlike click-on agreements, browse wrap terms do not require assent and are usually worthless. You can e-sign with an email. You do not actually have to have a real signature. An email that says, "This looks good to me," is a signature. An electronic sound, symbol, or process attached to or logically associated with a record and executed or adopted by a person with the intent to sign the record. That's all it is. It can be anything. It can be anything. There are some more modern technologies, and they're getting more sophisticated. There are still some things, however, we don't allow electronic signatures on. Now, e-signatures do apply to most of my court documents. In fact, I have to e-sign them. And that can be done in a number of ways, but I have to serve electronic documents. But things like wills, not only can those not be electronic signatures, they typically have to be witnessed by witnesses, humans in the same room. And then if you want to be helpful to the people who will be administering your estate, you also want to have a self-proving affidavit, which requires a notary. So there's still some things that we require physical signatures. But for the most part, you can e-sign anything. A partnering agreement can establish special access and identification codes to reduce the risk of fraud or other unauthorized activity. If you've ever bought or sold a house recently, you might have signed documents on your iPhone or some other kind of phone, and it is legally binding because you use an identifier or something like that. If you file with the IRS, you can do that electronically, and your signature will have a number. We use these kinds of ideas throughout and concepts throughout all sorts of areas of law. We are not concerned in this class with the Uniform Electronic Transaction Act. You might be tested over it just to make sure that you've read it, but this level or this act itself is a little bit above where we need to be. I want to point it out to you, but that's all we're going to cover in acceptance. Is just be aware that there is a Uniform Electronic Transactions Act. And that is, the design is to make it easier for people to form electronic contracts. It's really all I care you know about that. I think it's interesting to study, but it's beyond the scope of this class. Know that it exists and know what its aim is. We want to remove barriers to forming electronic contracts. We like electronic contracts. They help us get our business done.